Welcome to this webinar organized by the American branch of the International Law Association. It's a pleasure to coordinate this webinar and to welcome all these speakers today to talk about very important topics. And every speaker comes from different area of expertise, and we will be analyzing these topics from different perspectives. And as a whole, there will be the attempt to cover this aspect in the most interdisciplinary way as possible. So for introducing this webinar, the very first question I would like speaker will engage will be: how do indigenous legal order challenge the epistemic methodological assumption embedded within international law, comparative law, development governance, intellectual property, and international economic law? This webinar, entitled Indigenous Legal Order, Legal Pluralism, and the Coloniality of Method Across Comparative Law, International Law, IP Law, and Trade Governance, is not simply about adding indigenous perspective to existing legal framework. We really want to understand and try to address how much indigenous legal order can really challenge the epistemic and methodological assumptions embedded in various fields. And to do that, the discussion will move across multiple fields that are often treated separately, often treated as a silos, but which are deeply interconnected. We are going to move through indigenous legal orders and legal pluralism, comparative law and methodological coloniality, international development and global governance, intellectual property and traditional knowledge, cultural heritage governance, WTO law, trade governance and investment law, environmental governance and sustainability, and wherever possible, also digital governance and emerging technology. So through the various broader horizontal questions, I hope we will animate the entire panel discussion and covering a number of aspects which are also covered by some of the suggested readings prepared for the webinar to further expand these themes by emerging questions that can cover also cultural heritage restitution and the ontology of cultural object, legal personhood, and community-centered governance model, and a number of other regime complexity in IP, knowledge governance, genetic resources, disclosure obligation, human rights in connection with biodiversity. So the speakers we have today, all colleagues, you can already see Professor Elena Baylis, Professor Dana Jones, Professor Shidio Gumana, and Professor Sergio Alberto Gramito Ricci, and myself. We am working on various of these aspects. And so hopefully we will also have some time for questions at the end. I also want to remind that subject to the approval by the New York CLE board, CLE credit will be offered for this webinar. And toward the end of the webinar, I will also provide the CLE attendance code. So when this will happen at the end of the webinar, please write it down, as you will need the attendance code to request the CLE credits. And we will also receive an email with instruction on how to request CLE credit the day after the webinar. So I think I cover most of the aspects for this introduction and wants now to get us started. So let me repeat the main thematic question I want that we start to cover. And then we will continue. We will try to cover as many questions as possible. This is not this is a debate, a discussion format webinar. So every speaker will not present with a formal PowerPoint or presentation, but it will be more a discussion on the different perspective that each one of us will bring together to the public. So the question I would like to start, let me repeat it one more time. How do indigenous legal order challenge the epistemic and methodological assumption embedded within international law, comparative law, development governance, intellectual property, and international economic law? I would like to give the floor to Professor Chidi Ogwamaman, and each speaker, when they first speak for this question, are also welcome to introduce themselves, presenting their affiliation and their field of work, and then proceed with the response. Thank you very much. Chidi, the floor is yours.
Thank you, Paulo, and it's such a privilege to have been invited to share this platform with my colleagues. I am so happy that you raised this topic because it is probably one of the most interconnected topics in international law. And therefore, I'm going to make my intervention trying as much as I can to check all the boxes of the keywords that you have itemized. Please cut me off when I have done my time. And so my reflection is titled Indigenous Peoples and Local Communities Decolonial Struggle Over Transplanted Western IP. And I start with this African saying, which finds itself in so many other civilizations. That is to say, when a plant is transplanted without sensitivity to the ecology of its new destination, it risks dying or becoming an invasive weed that kills off native species while disrupting the ecology and ecosystem of its new environment. This metaphor captures intellectual property's experience with indigenous peoples and indigenous knowledge systems. That experience is an integral aspect of colonialism and its later mutation to globalization. Intellectual property's intersection with indigenous knowledge systems and its experience with indigenous peoples and local communities is a site of historical and colonial relations of power that perennially exposes epistemic injustice. Like all things colonial, the transplanted IP plant did not die. It was backed by enormous suppressive power. In a way, it can be likened to an invasive species, not a weed in the real sense. However, it failed to kill native species, that is to say, indigenous knowledge systems. Rather, it disrupted the knowledge production, ecology, and ecosystem of indigenous peoples and local communities. That disruption is monumental and, in my view, irrecoverable. My argument and answer to the question as posed is that indigenous peoples and local communities and their knowledge systems have in the past several decades constituted a source of pressure and of epistemic resistance, challenging and exposing the limitations and the gaps in the IP system and questioning the legitimacy of its universalization after the colonial fashion. Now, indigenous peoples and local communities have done this as a strategic endeavor through multidimensional solidarity and, perhaps most importantly, across multiple regime complexes that have not only questioned the orthodoxy of intellectual property, but also decentralized the discourse. On the environmental plane, we saw Agenda 21 and the CBD of 1992, the Nagoya Protocol 2010, the Paris Accord 2015, and the United Nations Law of the Sea Agreement on Conservation and Sustainable Use of Marine Biological Diversity of Areas Beyond National Jurisdiction of 2023. The contributions of indigenous knowledge systems on these platforms are now central to international law and policy making for innovations relevant to biodiversity and marine genetic resources conservation, relevant to biotechnology and to climate change. Now, on health, Indonesia's case of viral sovereignty in 2011 resulted in the Pandemic Influenza Preparedness Framework. that became the foundation for benefit sharing of vaccines and antivirals. This is now part of the post-COVID-19 global public health as headlined by the 2025 Pandemic Agreement, of which Article 12 speaks of Pandemic Treaties ABS Annex. On agriculture, the Food and Agricultural Organization's International Treaty on Plant Genetic Resources for Food and Agriculture of 2021 is the first major access and benefit sharing treaty. Article 9 outlines farmers' rights as the counterpoise to plant variety protection rights, which only caters to the interests of high-tech plant breeders. Farmers' rights symbolizes the endurance of the culture in agriculture, the traditional legacy of reproductive agriculture, as opposed to industrial or productive agriculture, which restricts the regenerative capacity of seeds and other propagating materials. Within the core intellectual property domain, indigenous peoples and their knowledge systems have pushed the envelope for mapping IP and human rights interface, which is captured in the 2007 UN Declaration on the Rights of Indigenous Peoples, otherwise called the UNDRIP. The UNDRIP provided the ideological fuel for indigenous peoples and local communities to challenge the rebuff of their knowledge systems by the 1994 TRIPS Agreement. TRIPS is silent, or so to say, does not recognize indigenous knowledge and its custodians as stakeholders in a globalized IP system. There are several bases to substantiate the contributions of indigenous peoples as well as local communities in the post-TRIPS backlash. Through their voices, indigenous peoples and local communities provided legitimacy to the WIPO in framing traditional knowledge and indigenous knowledge, if you like, as a major intellectual property issue of our time, and this is through the fact-finding missions of 1999 and 1998. That awareness provided the impetus, in a way, for the establishment of Intergovernmental Committee on Intellectual Property, Genetic Resources, Traditional Knowledge, and Folklore, what we call the WIPO-IGC. After 24 years of tenacity and strategic solidarity of indigenous peoples and local communities and their allies all over the world, the IGC delivered the first major development-focused intellectual property treaty centered on the intersection of the patent system and indigenous knowledge systems. Jurisprudentially, that treaty is an accountability and transparency mechanism that tackles the hitherto opaque patent system. It builds on the United Nations Declaration on the Rights of Indigenous Peoples and the progress made at the CBD over access and benefit sharing. The treaty mandates disclosure of origin or source of genetic resources and or indigenous knowledge as may be applicable upon which a patent claim is based. Even though conventional intellectual property has caused a lot of havoc on indigenous knowledge systems through colonial power relations of denial, denigration, and appropriation, it has also stirred what I consider to be counter-hegemonic and subversive responses. Those are symbolized through several new discourse and policy tractions, including biopiracy, access and benefit sharing, and related elements such as free, prior, and informed consent, and the necessity of consultation or participation of indigenous peoples and local communities in intellectual property decision-making and broader knowledge governance. Yet, indigenous peoples and local communities have remained unrelenting in decolonizing the IP system, consistently and strategically injecting concerns for ethics, equity, distributive justice, and the inclusion of their interest and representation in shaping the foundation of emerging technology frontiers. For example, this is pursuant to datafication, indigenous data sovereignty, digital sequence information, text data mining, large language models, natural language processing, and the overall AI ecosystem. So, Paulo, this is really my first take, trying to check some of the boxes that you have mentioned. And therefore, I want to really strongly say that despite how hegemonic the intellectual property system has become, indigenous peoples and local communities, through their allies, particularly in developing countries, and very strategic and important NGOs, have been able really to begin to challenge the suspect orthodoxy of the intellectual property system. Thank you very much.
This is great, Chidi. This is a great start. And I suggest that all the speaker will check also comments or questions in the chat or indication regularly while we speak, so we also can interact. But this is a great beginning. And I would like now to continue the conversation and give the floor to Professor Elina Baylis. Chidi, you did not introduce yourself. I was mentioning at the beginning that it would be good also that I know we should have done it at the beginning, but you do it now, that your affiliation, so it's clear for everybody. And then I can give the floor to Elina, who can also introduce herself and give her contribution and comments to the conversation.
Thank you so much. So my name is Chidi Ogwuemenem. I hold a research chair on indigenous bioinnovation, indigenous knowledge systems, and global knowledge governance at the University of Ottawa at the Center for Law, Technology, and Society. Thank you very much.
Thank you so much. Thank you so much. It's really a great beginning. Elina, the floor is yours, and thank you very much for joining us today.
Thank you, Paulo, and thanks to all of the participants. I'm really looking forward to engaging with you over the course of the next hour or so. I want to start my remarks with two brief acknowledgements. First, I'm joining today from Washington, D.C., which sits on the ancestral homelands of the Nacotchtank, who are also known as the Anacostan, and also the Piscataway peoples. These peoples were stewards of the land along the Potomac and Anacostia rivers for thousands of years, and indigenous peoples continue to live in and care for the region that I'm speaking to you from today. I also want to acknowledge that I am a white legal scholar and I'm trained in the US legal tradition. So I'm an outsider to indigenous legal orders, and I don't speak for any indigenous group. In the US alone, we have over 575, exactly actually, as of just a few months ago, 575 federally recognized tribes. Each one of them is a sovereign government. We have many additional tribes that are state recognized or not yet recognized, and they're all having their own cultures, histories, legal traditions, and perspectives that are often different from one another. So what I'm bringing to this conversation is really a comparative perspective that's grounded in mechanisms of dialogue and engagement between communities that are in conflict, which draws on work that I've done over many years in post-conflict justice and in legal pluralism. I am a professor of law and the Associate Dean of Experiential Learning at the University of Pittsburgh Law School, and have spent most of my career working on international law, comparative law, post-conflict justice, and the relationships between international, national, and subnational communities. With all that framing, my focus is going to be on speaking to the topic of cultural heritage restitution. So I'm pivoting a little bit from the IP questions that we were just hearing about. And I'm going to focus specifically on a particular example, which I've been doing an extended case study. And that is the Native American Graves Protection and Repatriation Act, which in the usual US government fondness for acronyms is referred to as NAGPRA. For those who aren't familiar with it, NAGPRA is a 1990 US federal statute. It requires federally funded museums and federal agencies to repatriate Native American human remains and cultural objects to affiliated tribes and Native Hawaiian organizations. Since 1990, it has facilitated the return of more than 2 million cultural objects and more than 100,000 ancestors. So one thing that's notable about this law is that for all of the many flaws and issues, it has been remarkably successful in attaining those returns, although there are many human remains and cultural heritage objects still left in museums and federal agencies. The law was enacted in response to decades of advocacy by Native leaders, and it was recently significantly amended. There are some new regulations that took effect in January 2024, and it's these new regulations that are one of the lenses through which we can see the effect that Native advocacy has had on the legal orders, the official U.S. legal orders over the course of the 35 years that NAGPRA has been implemented. So I just want to flag a couple of things at the beginning, and then I'll dig into some of the specifics about the relationship between the Indigenous orders, the U.S. federal law and implementation, and international human rights and Indigenous peoples law as we go through more specific questions later on. But a couple of things that I think are important for framing the perspective that NAGPRA gives us on these questions. First, NAGPRA is really unusual in being a mandatory binding legal repatriation mechanism. In this field, returns to Indigenous peoples and returns generally of colonial era heritage are usually voluntary and they're usually policy driven. So this is a rare circumstance in which there is in fact a formal law that was put in place that requires repatriation. The second thing that's interesting is how it was framed, the purpose of it, again, from the U.S. perspective, from that legal perspective. The purpose was stated to be explicitly to right historical wrongs to Native people, and also, interestingly, to enable and facilitate better future relationships between Native American tribes, Native Hawaiian organizations, museums, and the federal government. So it has this forward-looking aspect, and I think having that in it is part of what has enabled tribes and Native Hawaiian organizations to influence and shift to some extent the way that NAGPRA is used and implemented, and specifically the extent to which it takes account of Native knowledge, Native frameworks, Native understandings of cultural heritage. At the same time that it has this purpose and opens some space for that conversation, NAGPRA still maintains the colonial power relationship by centering decision-making authority in the hands of museums and federal agencies. And because this is baked into the statute, it's part of the essential statutory framework, it can't be changed in response to Indigenous advocacy, except by actually amending the law. And so that means that there is, on the one hand, some space for shifting, and on the other hand, we see this very strong constraint on what can actually be accomplished within the framework of this particular law. So I guess there's a sort of both and answer to the question that Paulo has posed for us. Can it have some effect? Yes, absolutely. And there's some very visible effects that I'll discuss as we move on with the conversation. But also there's a limit without significantly rewriting the law on the extent to which Native perspectives can affect NAGPRA implementation. The last thing that I want to flag about NAGPRA for purposes of this conversation is something that I'm focusing on in an article that's going to be coming out later this summer, and that is that its core repatriation mechanism is not built on trials or arbitrations or government commissions, all the standard mechanisms, right, of the U.S. legal system. Instead, it's built on direct dialogue between museums and source communities. And so once again, this served to open up space for transformation, but also because of the colonial power relationships that continue to structure those conversations, it also limits at the same time. I see it as being both a valuable model and a cautionary tale, because this design has meant that the dialogue in practice has produced highly varied results. So I use intergroup contact theory and international justice frameworks like restorative justice, reparations, transitional justice to assess how and why this NAGPRA dialogue succeeds in some instances and fails in others. and what that means as we look more broadly and comparatively at other models that are being developed and implemented in Canada, New Zealand, Australia, and also in other places around the world. So I'll leave it there, and I look forward to digging into some of the details and nuances of the relationship between native and US and international understandings and knowledge frameworks as we move ahead.
This is great. Thank you so much, Elena. You managed to, like Chidi, to unpack so many things in so little time. And we cover, again, thanks to you, another important area of this webinar. Several areas, I would say. And I feel that it connects also pretty well that the comments and the research that also Sergio is doing in his research. So I would like to give the floor to Sergio Alberto Gramito Ricci, please, as well. Like every other speaker, introduce yourself, and the floor is yours. Thank you so much for joining us today.
Thank you, Paolo. Thank you, Paolo, for having me today. And I want to thank all my co-panelists from whom I'm learning a lot. I am an associate professor of law at Hofstra School of Law. I'm also a co-founder and president of the Center for Retail Investors and Corporate Inclusion. That obviously suggests that I come in from a corporate law perspective, which is my main thread of research. But within that framework, I also research corporate entities and legal personhood. And in researching legal personhood, I delve deeper into the issues that, Western legal framework raise with respect to the protection of values that are different from typical Western values, such as monetizing on inventions or monetizing on investment in projects. So I want to place I want to place some emphasis on the role of perspective. And the role of perspective is essential not only because I'm also trained in the Western system, but also because I really come in from a specific area of law. However, I also, because of the specific line of research, I was also appointed on the executive committee of the American of the AALS race and private law section. So obviously, the point that you made before, Paolo, of interdisciplinary work is key here. And I want to just raise at the very beginning of this conversation, and I'm happy to talk more about my work and my articles, but I want to raise some specific aspects with respect to the framework. I think that it is important that we look at structural governance of issues, and I believe that's how I can contribute to the conversation, being a scholar who looks at structural governance. But I also want to place emphasis on this dichotomy between different ways of approaching policy, for example. If we want to approach policy looking at individuals, which is classic Western approach, rather than looking at collectives and communities. If we want to approach policies with respect using a certain systems of value, for example, as I said before, monetizing rather than protecting the spiritual nature of natural features or spiritual nature of traditional knowledge. And also, drawing a contrast between key concept in Western legal system, which is property versus stewardship, right? So I think that when we want to embrace the paradigms that govern and drive cultures, and obviously indigenous cultures as well, it is very hard to provide, it's very hard to approach policy making unless we really recognize the differences in the roots and in the perspectives. So one aspect that I looked at in my work is how intellectual property doesn't really provide a good framework for protection that is sought by indigenous communities with respect to cultural heritage, traditional knowledge, arts, dances, and other forms of intergenerational interaction and intergenerational creation of values for communities. And I suggest the use of legal personhood to protect works of art, to protect traditions. And this is, an argument that I developed in an article titled Legal Person for Artwork. But this is just one small piece of a much bigger picture that is really rooted in some differences in the system of values that I referenced before.
Thank you very much, Sergio, for your contribution, and we will get back to you with the next round of questions. Let me now give the floor, and as you clearly demonstrated, we really need to be from many different fields. I would say not only from legal fields, but already if we are able to bring different fields in the legal field to cover these topics, it's already extremely important and helpful, and to address the complexity of these matters. But it's also very relevant to bring at the table other disciplines. But this we will do for another webinar. Let's start with this one, and to have another perspective, and definitely an important perspective, considering the area of emerging technology in general, and several other fields. I would like also to give the floor to Professor Dana Jones, who can introduce herself as well, like every other speaker, and bring her contribution. And thank to you as well, Dana, for joining us on this webinar today.
A pleasure to be here. Thank you for having me, Paolo. Thank you to all of my, the rest of my wonderful panelists and all of your intellect and experience that you're bringing to this panel. I'm going to be very brief because I know that time is of the essence and we have lots to discuss today, but I am Dana Jones. I bring you greetings in between two wonderful law schools. I am presently assistant professor at North Carolina Central School of Law, but my destiny come July 1 will be the director of the Health Law Institute at Mitchell-Hamlin School of Law, where I will be associate professor of law there, directing the Health Law Institute and taking it to the next level of emerging technologies. And so there, just a couple of months ago, I had the wonderful pleasure of doing a couple of things with Paolo. First, engaging in a symposium on tribal sovereignty, and at Mitchell-Hamlin, that actually sits on historic treaty lands of the Dakota people, have actually gotten more involved in this idea of tribal sovereignty. So it is wonderful to always be a dog that can learn a new trick, right, and have a new investment and appreciation for all of the things that people in our wonderful continent can bring to this area. What I do is I do bring knowledge and a background in emerging technology. One of the theoretical frameworks that I have developed in my paper, Supremacy Politics, the Coding of Power in Artificial Intelligence, is I bring a lens of healthcare equity and politics and artificial intelligence and algorithmic decision making and how that works in our U.S. Healthcare system. And so I have definitely looked at that, examined it, and in our topics today, want to bring a perspective of how epistemic erasure is happening to bring about this injustice that is occurring with tribal sovereignty, that's occurring with marginalized communities, and how some of our federal regimes and how our state environmental rules are actually doing some things that are changing the way our communities, whether it is our tribal governance systems, whether it is how we view healthcare within our marginalized communities for elders, whatever that is, and whether we're looking on the international stage as how we look at medical devices, how we govern AI or lack of governance of AI in this time, but how all of those things impact our economy and how it ultimately affects our erasure potentially of marginalized communities, not only in the world, but more importantly in this fake world, I call it, of artificial intelligence. And so that would be my contribution to today's questions that we pose as we look at all of these wonderful concepts in international law, comparative law, and legal pluralism today. So thank you, Paolo, for having me, and I look forward to us engaging in some great conversations over the next few minutes.
Thank you so much. Thank you so much. So as I was saying, Chidi and Elena, international and comparative law, and much more than that, property, intellectual property, trade, Sergio corporate law, Dana Jones health law, technology law. So we are really covering different aspects with this, and we cannot cover everything in 1 hour. And so that's the reason why we have provided also readings for those attending the webinar. But let me continue this conversation. Everybody has acknowledged, I also need to acknowledge a number of things before moving on to the aspect. So first of all, I have already thanked the American branch of the International Law Association, but I also want to refer to the fact that this event, this webinar, and there are other events in preparation for the International Law Week and in New York City in October at Fordham Law School and others, is organized by a newly established American branch of the International Law Association Committee on International Law, China, and the reconfiguration of the global order within the framework of the American branch. And this committee and another group, which is a study group, which has been recently approved by the Executive Council of the International Law Association in London headquarters, has approved the establishment of a new study group on international law, global challenges, the impact of the emerging power on global governance, which I will have the pleasure to lead, will be then very soon open to membership across the world with all the branches of the international law associations. And the topics we are covering today will be definitely there because global challenges include also try to balance global and local. And among the global and local issues, of course, indigenous issues, cultural heritage, and the many topics we are covering. So we are just getting started in that sense. And that was another thing I wanted to mention. And as someone currently teaching at the University of Tulsa College of Law, I would also like to acknowledge that our law school is located on the reservation of the Muscogee Creek Nation in a region with deep historical connection to the Muscogee Cherokee, Osage, Wichita, Caddo, and other indigenous people. So these are not merely historical questions for anybody working in Oklahoma. Our question of tribal sovereignty, jurisdiction, indigenous legal order, and relationship between indigenous and state legal system remain living and evolving reality. So in addition to my role at University of Tulsa College of Law, I've been a professor of public policy and public administration at West Virginia University, and previously also a visiting professor of law at University of Pittsburgh Law Schools, where I met dear colleague Elena Baylis, and from that moment we have been in touch, including for this webinar. So I would like also, in addition to my role of moderator, have some intervention on my side because I've been working on these topics. So I really appreciated the many references that each one of the speakers has made. One that I want to refer, because many have been mentioned, Sergio has referred to the term of structural governance, which I like a lot. And I've been working on what I call epistemic governance, which is indeed one of the aspects that has, let's say, made me thinking of the organization of this panel in a way that we need to re-question the status quo of the law with a critical mindset, I would even say with a critical legal theory perspective on these topics, and questioning the legal orders as an epistemic governance issues means to question whether the legal order has been set for everyone or has been set for some specific groups by those groups maybe in that moment in power. So question I address for everybody in this first round of reasonings raise legal pluralism, representation, participation, expertise, legitimacy, the role of indigenous community, not only within international governance structure, but within the law in general. And so this is some of the issues we definitely would need to continue to work, not just today. One of the issues that emerge across several presentations and the materials we share is whether the indigenous legal orders are merely being recognized by state and international institutions, or whether they force us to reconsider what counts as law itself. So much of the international law remains structured around state-centered assumption regarding legal authority, yet indigenous legal tradition often challenge those assumptions through a relational, community-centered, and place-based understanding of governance. And some of those references have been done by all of you in your previous comments today. So does genuine recognition require institutional accommodation, or does it require a transformation for our underlying legal category? So that's really, for me, a very important question on legal pluralism versus assimilation. But let's move on. That was my, as well, contribution to the conversation to this first question, but we are already 45 minutes inside the conversation, and we just started to respond to the first question. I would like now to go through other questions and suggesting that now that each one of us had a little bit more time to introduce our topics, that we can have maybe responses of 30 seconds, 1 minute each for some of the questions. Not everybody has to reply to every question, so I will just start the questions, and then without a order, anyone that feel comfortable to get started or go on with the question, that would be great. So one of the questions I had on my on my notes, the next question will be, can comparative law genuinely move beyond Eurocentric methodological assumptions? And I would like to give the floor to any of the speakers that would like to take this question ahead. If anybody feel comfortable to take it, to break the ice, or I can ask other questions as well. Maybe Chidi, would you like to take the lead in this question as well for 30 seconds, 1 minute? Meaning the impossible mission, the $1 million question, you need to respond in 30 seconds, 1 minute. You are muted. You need to unmute
That
yourself.
is actually, Paulo, a $1 million question. Whenever I hear the phrases like law, comparative law, indigeneity, TK, intellectual property, what comes to mind is there is a presumption upon which the word law is used. And in the colonial framework, it's always from the Eurocentric presumption. And the whole idea of law, which actually is a book, the idea of law is a matter of what pedestal one is standing to talk about law. So it is difficult to read law of Eurocentrism because of the colonial framework under which law is introduced to other civilizations. And therefore, when indigenous peoples talk about indigenous legal orders, some say indigenous legal traditions, the whole attempt is to appropriate the governance systems that really define these civilizations to an Eurocentric model. So even when we talk about recognition, they're talking about who is recognizing what. And there is a presumption of power to recognize. And that is why in the framework of colonialism, you show up and say to people, your language is mumbo jumbo. Your land is not occupied. It is terra nullius. And then you say, we are introducing the concept of intellectual property, which, as we understand it using the English language, is the creation of the mind. And right away, you are talking about the creation of the mind can be propertized. And that is Eurocentric. It is not so, as the Sergio was saying, in other civilizations. So in order to really begin to decolonize this framework, we have to really probably break down the building and start afresh so that everybody will be on the same level in the conversation. Other than that, Eurocentrism is something that we cannot completely rid of the way we govern knowledge. It has come to stay. It has penetrated into the DNA of knowledge governance. And the best we can do is to begin, just like indigenous peoples and local communities have done, to begin to question with some kind of counter-hegemonic narrative, begin to really claim our own epistemic space in this power-laden conversation. So that is just my take on it.
Thank you so much. Thank you very much. Elena, you want to go next with your comments as well?
Sure. I think that in some ways, NAGPRA is really a concrete case study of this challenge. One of the reasons that NAGPRA was enacted was because museums had historically rejected Indigenous understandings of their own cultural heritage. And they had also historically rejected the sources of knowledge that Indigenous peoples offered to reclaim that cultural heritage. So NAGPRA itself was intended to acknowledge and legitimize within the U.S. legal framework that alternate, the Indigenous pre-existing knowledge system. But because the structure of the interactions remained the same, museums and federal agencies maintained decision-making power. Their traditional knowledge, native knowledge, was still not fully recognized and acknowledged, and other forms of evidence were seen as more persuasive. So one of the things that the 2024 amendments do is to institute native knowledge, native understanding in terms that the Eurocentric system can understand by referring to it as expert opinion. And insisting that museums and agencies have to defer to it. So it creates a larger space in which native tribes' knowledge and understanding is supposed to prevail, while still keeping it within a kind of pre-existing process. So again, it presents this tension that continues to pervade the entire NAGPRA system.
This is great. Thank you so much. It combined very well with the response of Chidi. Dana, you wanted to go next as well?
Yeah, ultimately, I think the issue is similar to what Chidi was saying, is the difficulty of breaking this down is that we have experienced, especially in an AI system, for instance, in healthcare, a Eurocentric methodology. And the assumption is, for instance, we've been dealing with racism and bias in our US healthcare system for so long that it is built into the structure. And so how do we actually break down a structure that is inherently biased, inherently built into the machine? And it takes work to do that, right? I love Alina's comment that says that NEPRA is actually going to, and I hope I pronounced that right, but is going to actually look at indigenous and sovereign people's positions as expert opinion. And so, but, again, look at the fact that we have to classify a sovereign group's, understanding who they are, what their artifacts are as expert is actually the epitome of ridiculous, right? And so, which actually, aligns with what the Daubert test is, similar to your work that you actually talked about, Paolo, in your work in epistemic governance in the first place. That aligns with your paper where you talk about that. But the bottom line is we have to go so far in deconstructing this entire thought process, and deconstructing and actually getting down to the bare bones of this is really going to take a lot of work to deeply to unwind some of our bias, especially when we start looking at the fact that we are rolling back so many of the things that we have gone so forward in some of our even cultural exchanges right now presently.
Thank you so much, Dana. Deconstructing. Yes, this is definitely a word that in a way or in another, Chidi, Alina, yourself, myself, Sergio, we are saying without saying, or we are saying clearly. So thank you for pronouncing it clearly. And yes, that's also as well what I feel. So the question that I would ask myself to respond to the question, can comparative law generally move beyond Eurocentric methodological assumption? I ask another question to myself. Are we still using a map of the legal world that was drawn primarily from European experience? If so, what would be a more inclusive map look like? And when I say map, I really think about number of issues of legal cartography, legal geography, and governance, because even geography, for example, has its own epistemic governance. You think about how cartography are done, that certain continents look like bigger than what they are, and other they're much bigger, they look smaller. Coincident, I think, which ones look bigger and which ones look smaller. Generally, the global south looks smaller when they're much bigger, and the global north look much larger and they're smaller. And this is an issue of power with the decision maker to make this type of reasonings. So many of the things we are covering on legal categories themselves may reflect then particular historical experiences. So comparative law often presents itself as neutral, but many scholars have argued that the field was built largely around European and Western legal experiences. So, for example, exactly what Chidi was saying, it resounds so much in what I'm thinking as well in the research. Law is not confined to the state. Legal order is an autonomous normative system with internal coherence, and this has implication in so many different fields. Beyond indigenous legal system, we need to think how this implicate other. For example, you, Sergio, are working on corporate law. This has implication in corporations, the legal order as an autonomous normative system. Corporation, religions, sports, markets, they all own their legal system. Why not indigenous system? So the examples, there are a number of examples of accepted non-state legal orders, like the Lex Mercatoria, commercial arbitration and global trade norms, or the Lex Sportiva with the Olympic tribunals and the FIFA rules. These are recognized despite no sovereign enforcement. So there is indeed then a risk of a double standard. So Lex Sportiva, Lex Mercatoria, FIFA, Olympic tribunals, commercial arbitration, global trade norms, money, and Western categories and Western standard recognize them as their own legal system, but indigenous legal systems are denied similar legitimacy. This goes back historically to the terra nullius, land deemed legally empty if not used per European norms, and everything that is related to the doctrine of discovery, the papal bulls with legal theology as imperial license. So in a nutshell, indigenous law result as a non-law. This for me is really a key aspect and resemble in many of the different speakers are talking about. I just want to refer just to one last point, a specific case that was interesting for me to analyze. The Opi Katsina dolls case was between United States and France. So there was a sacred ritual items treated as art and action in Paris. And Hopi invoked spiritual harm and customary law. So Hopi was an indigenous group from United States. So United States Department of State was dealing with French authorities and the French court on behalf of the Hopi group and invoked the spiritual harm and customary law. And French courts that generally are open to consider religious matters were not considering the Hopi as a religious matter. So the court upheld the sale, private property, and spiritual sovereignty. So the key lesson I brought, the outcome was that eventually there was a voluntary return by the buyer and there was no legal remedy. And so the customary law has limited cross-border force, transnational legal tools are inadequate, and so public pressure was stronger than formal litigation. That makes us thinking, then do we really have a fair system, a fair legal system? If we need only public pressure to reverse this type of decision, then we need more than the law, as we were discussing. We are now closely approaching hours. So I again want to bring on the table another question. Let's see, then we can take also from the questions from the public. The other question I would like speakers to engage. Some of the other questions we engage on directly with the responses, but this one I would like to take it more deeply. What counts? Some of those as well cover it, but I would like still to see if there is anybody among the speaker who would like to take more about that. The question is, what counts as law, knowledge, evidence, or expertise within global institution, and who decide? And this connects also to the next questions. Does legal pluralism merely accommodate difference with existing structure, or can it transform the foundation of legal governance itself? I don't know if there is any of the speakers. I'm posting the questions in our chat. any of the speakers that would like to take. Maybe Sergio, you want to go first?
Yeah, like I have a general consideration I would like to share with you all. And, this really became evident to me when you were speaking, and even because the great points that you just made. And especially, I would like to go back to the question you addressed, but you also share with all of us on comparative law, right? Or like, can we actually apply comparative law when we talk about indigenous traditions, for example, or nations or communities? And I think that we should go probably a few feet deeper and consider whether systems are always governed by the law, or there are other mechanisms, there are other models that govern systems, that govern societies, right? So if we just take a classic approach by differentiating um, shame culture from guilt culture, like not all system, not all society really need a very strong legal framework, because issues and traditions and the behaviors can be governed by models that pre-exist the law. For example, the importance of reputation, the importance of shame, the importance of traditions. So in tackling this topic on an international comparative level, I think that we want to really recognize that we should start from a deeper understanding of models beyond the comparison of legal systems per se, right? So, the role of religion, the role of, spiritual traditions, the understanding of how the beyond life, horizon also impact how people behave in a society. There are very, very deep aspects that need to become part of the conversation, both from an institutional point of view and from a comparative point of view. So this is just a contribution to the general framework of the question you just posed.
Thank you so much, Sergio, for breaking the ice also with this third round of questions. Dana, go ahead with
Yeah,
your contribution.
very quickly, because I know we have to end, but just to respond to what Sergio was saying, I think the other part of that, when we start thinking about traditions and those things, I think we find ourselves and could find ourselves on a slippery slope, because what happens then is we have to balance morality. And when we start balancing morality, then that's where we decide, who can marry. And then more importantly, what will govern and who should be able to govern. And some of these other decisions, that we are now right here, like I kind of mentioned before, we were so close to having a society where we did not see certain rollbacks as to DEI in our system. Really, what was DEI, right? It was just a mechanism to create what we thought was diversity, equity, inclusion in the system. That did not necessarily mean that because you were African American, you got a hand up. It meant that we wanted our workforces in the U.S. to reflect what our U.S. employment situation, what the U.S. looked like by way of, who we were as a system overall. And so when we start looking too much as to what right and wrong may be, that, governance as far as what we do in our households, right? I think that's why we need the law. We need the law to try to have some self-correcting in some ways. But here's where we get off the slippery slope, because then when we interject morality is where I think we're having a lot of issues now with people in putting their own influence into what should just be black letter in some ways.
Thank you so much for this warning. I would call it, because it's really important. I do the same even with students in my classes when there are certain, I would say, proactive arguments on legal issues that would say, this would be important to state it in the court. And I say, yes, but be careful what you are asking for, because that could be used in other terms, in other cases that could change then the perspective. The same is here. So I would say that we need to be careful in what we use and what we expect, because then it can be also used in other contexts and modify the final result. But Elena, go ahead. Thank you so much. Dana?
Thanks, and thanks for those really interesting interventions. I think these are some of the questions that I have always found most interesting. I've looked at questions of how legal pluralism operates and the role of different kinds of knowledge across transnational initiatives in post-conflict justice, parallel courts, hybrid tribunals, cosmopolitan pluralism. So, you've hit on something I'm really fascinated by. And the one piece of this that I want to bring into the conversation is the question of designing processes. So if we have this question about whether or how really institutions can change, or really these systems can change, and what we're going to take into account, part of it is the dynamics and characteristics of the processes that we create. And so we see this with NAGPRA as with other things. We see the NAGPRA dialogue sometimes serving an accommodating role, but at times actually serving a transformative role, and at times simply shutting down conversation altogether because of the very limited requirements that are put on that process. But I think that one framework that we can look to pull on what Sergio was saying is less a substantive framework or an incentive-based framework, and more a process-based framework. How do we create a dialogue and engagement that enables everyone who's a stakeholder to participate? And that's where I think there's some very interesting work done in social psychology, intergroup contact theory, because it tries to name the characteristics of the process that are necessary to hear voices that don't already have power in the system. Things like equal status within the system, a process that is cooperative and has goals that all stakeholders hold, that they need to try to reach through common effort. So there's these ideas that come from outside legal systems, but aren't based on putting forward certain values, but rather on creating space for genuine engagement that could be transformative.
Thank you so much, Elena. Chidi, I see your hand raised. Go ahead, please.
Thank you. So let me just say, I was so excited when you talked about the Hopi and the court in France. And that is basically talking about what is the law and who actually makes the law, who determines what is knowledge and what is the evidence. So that right there is international law at its best, because the Hopi cannot be recognized in their spirituality and religion, because international legal system is Eurocentric for the most part. Francesco de Vitoria told us all about it. That this is, you talk about justification of war was based on subduing alternative voices and religions. So the law, from critical legal studies perspective, is about power. Law is in bed with power. I'll give you an example. The process of trying to even begin to have conversation around indigenous knowledge within the intellectual property space has taken, if you like, centuries for it to even begin to find traction. But what happened when we started having artificial intelligence? We're having a conversation about copyright over AI-created work. But we've been struggling to even have a conversation about how to give credit to oral civilizations that do not write. So from my vantage point, talking about patent law, it is created by power. And the expansion of intellectual property has been a matter of what corporate entities have the influence in corridors of power to determine whether business models, whether artificial intelligence can even begin to dominate the space for conversation around intellectual property. But how about indigenous peoples and their knowledge systems? They are still pecking at the periphery of knowledge governance that can be recognized. So it's a matter of power and influence and nothing more. For me, as a critical legal scholar, that is what you see happening. Who recognizes what counts as law? What counts as knowledge? I mean, my mother way back in Africa would do genetic selection of the right kind of seeds when there is drought. But somebody wears a test tube, a lab coat, and goes to the molecular level. That person gets a patent. The other person is not even recognized. So that is really where power plays a significant role in terms of what counts as law, what counts as knowledge.
Fantastic. Thank you so much. And I appreciate also the additional comment you made, Chidi, because for me, and you say many things, but I refer to the reference you made to the Hopi Katsina dolls, the case I was referring as well, but there are so many other cases. For me, it was interesting to address that because we're talking about Eurocentric, Western categories, Western legal orders, and here we have US opposed to France, right? So that was for me interesting. Of course, I know it was specific issues about the Hopi indigenous group, but was still represented by the Department of State of the United States opposed to France. And differently that if we take other cases like the Hodia plant and some people in South Africa, or the Y262 claim, New Zealand, or the Sami-Dogian cultural labeling with Nordic countries, those are more, you wouldn't more expect this type of situations, but here we do have it in the United States that itself, sometimes, I would say more than sometimes, treated as an outsider to the European legal assumptions. So the United States is treated as an outsider of the European legal assumption on indigenous issues. So that's, I know it's a very long conversation, but historically many comparative law narratives were constructed around the distinction between civil law tradition, France, Germany, continental Europe, and common law tradition, England, later the United States. While both belong broadly to the Western legal tradition, they have developed different approaches to property, religious, cultural heritage, indigenous rights, and judicial reasoning. That are all topics we are covering in this webinar. So really the question is, if comparative law seeks to move beyond Eurocentrics, is the United States itself sometimes treated as an outsider to European legal assumptions? Right now, for everything is going around the world, in particular, everything that is happening in the United States, the answer would be probably not now, not here and not now. But it was still interesting to raise this type of comparisons and see how the United States has dealt with this matter, and Canada has dealt with this matter in a different way than Europe. Do I mean that Canada and US did deal with those issues completely well? Of course not. We have so many things that needs to be fixed. But again, it does show that the historical component, the ethnographic, the sociological, the different places do deal with this matter in very different ways. So we cannot, as lawyers, be alone in this type of challenge. We need to bring at the table historian. We need to bring to the table anthropologists. We need to bring to the table expert on cultural management and cultural negotiation. to be able to really go deeper in understanding why certain things are in the way they are, and why certain things are not in the way you would be expecting and hoping to. So this is a little bit what we would like to try to cover in these two committee, in the American branch, Committee on China, international law, and the reconfiguration of the legal order, and the new study group of the International Law Association on global challenges, international and global challenges, and the impact of emerging powers on global governance. Because until now, maybe not today and maybe not yesterday, but until recent time, everything seems to be dealt by European standards or American standard, North American standard, British standards. Now seems that we really are in a multipolar world where China has a say, India has a say. I don't want to say other countries that they are dealing with their say with the use of force, unfortunately, but this is not the topic of today. But still, we are dealing with definitely a multipolar world of global challenges. And to remember this, the centrality of indigenous issues and indigenous legal order, I think it's extremely important right here, right now, in the middle of these bigger issues of global challenges. We are now up with the time, but I really want to thank every single speaker today for the contribution. This was a very, at least for me, I hope for everyone, among the speakers and those who are attending and those who are going to watch the recording later on, will be diffused and disseminated through social media in the American branch of the International Law Association, ABILA. We have already responded directly to one of the questions that was made by the public, but we can stay a little bit longer. If there are additional questions, I would like to invite any of the attendees to ask questions. And directly, I responded, and Chidi and some other of the speakers responded to one of the questions that was asked. What institutional reform would be necessary within the international organization to operationalize respect for indigenous legal orders in dispute resolution and policy making? I think that the combination of my response, Sergio, Chidi, Dana responses did cover this question. But if there are additional questions from the public, this would be the right time to post them in the Q&A section, so we could address additional ones if there are any. Chidi, you want to add anything? I see that you are muted. Anything of the asked question? I don't see any new questions in the Q&A section, but if you wanted to say more.
The question that was asked about the one we seem to have answered already. What I have always said is that given the increasing importance of indigenous peoples and knowledge systems, for any platform or policy space, I've always said that we should ask the indigenous knowledge or indigenous people's questions. Even in conflict resolution, in arbitration, in any policy space, that is always something that is a blind spot. And we say, ask the indigenous knowledge questions. In other policy spaces, they will say, could you imagine what can be an indigenous impact assessment? So this is the consciousness that organizations and institutions bring, whether at corporate or private level, or even public level, in order to really begin to understand the very importance of indigenous knowledge systems as a very critical part of legal pluralism. Thank you.
Thank you so much, Chidi. I do completely agree. I see, for example, that even in the framework of the United Framework Convention on Climate Change, more and more indigenous people are involved. In international context, many small islands are getting involved with disputes for climate change. And many of those small islands as well represent and include indigenous issues. So there are a number of issues that I would see very positively on how we are getting closer to a better framework for indigenous legal orders to be considered. But yes, there is so much that can be done more, and each of that can be done in a better way if the questions are asked and potentially answered by indigenous groups direct. But I really think that those groups needs to create bridges, and we need to create bridges with those groups to interface. And sometimes already discussing those topics mutate the conversation. You reference that with legal English or English, the language already you use and the terminology of legal for certain indigenous groups do not exist the translation in their language of some of the terms that we are using. So how can you even have a conversation about property, about ownership, if the concept doesn't even exist in the society? And so if it doesn't exist the concept in their society, it does not exist the word to define it. So we do have this type of barriers that create a lot of distance, but we need to try to find solution. Or the risk is in many areas that corporate business and multinational companies will benefit from the lack of protection for these issues, and countries or states that do not recognize indigenous people could negatively affect sometimes their own indigenous groups and sometimes indigenous groups of other countries. So it's really, I would say, a lot of work, a work in progress. And maybe today we have set some of the topics, and we can continue definitely the conversation and we're asking questions and try to find answers. I don't see any additional questions. I want to thank also the attendees asking these questions and every other attendees. And probably it's now time to, if there is any last comment or any additional reaction. If not, I would thank every single speaker, Dana Jones, Sergio Alberto Gramito-Ricci, Elena Baylis, Chidi Ogomaman, and Laurie Farid for the coordination of this webinar and for managing our webinar tools. I look forward to share this webinar link with any other participants. So those who are participating, you can let others know that there will be this opportunity as well to watch this webinar later on. Thank you, everyone.